Rebecca Stadler. This is August 2018's Pirate Fight Club. What we usually do is a fairly informal presentation. I get started a little bit on intellectual property background, and then we can kind of jump into questions. The only thing that I recommend is that if you've got a specific intellectual property question, try to put it more generally as possible, because otherwise you're disclosing your intellectual property, which is not what we're encouraging at Pirate Fight Club. The idea being to prevent piracy of your own intellectual property, and of course not to pirate other people's intellectual property. So with that mouthful, I can just jump into generally what intellectual property is. It covers products of the mind for the most part. Patents typically cover inventions, so air conditioners, any type of automobile parts, anything that's in your smartphone, things along those lines. Copyright covers original works of authorship, so photographs, so we've got a couple photographs in here, paintings, video recordings, television programs, movies, things along those lines. Trademark is a little bit different. It identifies the source of goods and services. So the ultimate goal is to protect the consumer, but the benefit does end up going to the owner of the trademark. So if you think of Ford, they were able to use their little blue circle as part of collateral against their $25 billion loan about 15 years ago, 12 years ago, when they decided not to get a government bailout, and they took all of their assets, including their trademark, and put it up as collateral against their loan, so that they could restructure and get themselves on the right track. And I find that kind of fascinating because I'm a little bit of a nerd. But so those are the different categories. There is something called trade secret, and almost every business actually has a trade secret. So if, for example, our business has an email list, and we send out emails every month, so that's our trade secret. Nobody else has that list, and it gives us a little bit of a competitive advantage to get in touch with our former clients or existing clients or people we've met along the way. And so that's one example of a trade secret. There are others.
I'm not sure if it's trademark register, what term you would use for a certain name that I want to create a program for within my business, and then might be somewhat part of a brand going in the future.
Yeah, so that would be trademark.
But I have a colleague who's actually going through some issues with somebody who's got a similar name to her business, and she's fighting them to, stop using that name. So I never really thought about it, but I may need to do something with my name as well.
It ends up being a big problem at some points. So is this the name of the business that you want to use?
I'm actually already doing business under that name.
Okay, as an LLC or a DBA?
Yes. Oh, I did the LLC, yes.
Okay.
That's what Diana helped me with.
Okay. So you could potentially trademark this name if nobody else is using it. You don't necessarily have to. The risk of not trademarking is that somebody else might steal that name, and then start doing business, and then it would become confusing for your business. So if are you doing this mostly on a local level?
Mm-hmm. Yes.
So locally, you're probably protected under New York State unfair competition laws from anybody else locally using that name. If you wanted to branch outside of Western New York, then you'd want to start looking at a federal trademark registration. And that just, so the federal trademark registration would protect you across the country. So if you wanted to start doing stuff in Pittsburgh or Rochester or something along those lines.
So like if I franchised.
Yeah, and so that's a lot of work, and it's sort of a lot of planning. So it's hard to say whether you would really want to do that. Is that what Diana recommended, that you potentially trademark?
Well, I was actually wanting to come up with a specific program.
Okay.
And there was a specific word that I wanted to use
Okay.
to identify that program that would kind of be a type of brand to be known for,
Okay.
without saying things specifically.
Right.
So that specific word, I was thinking about protecting, so I
Okay.
could use it within my business.
Okay, in connection with the program. Okay,
Yeah.
that makes a little bit more sense. Okay, so then we wouldn't necessarily trademark the business name, but we could look into the program. One way a quick way to see whether anybody is using that trademark is a quick search on United States Patent and Trademark Office's website, uspto.gov, which for the past 5 days or so, there's this big yellow box saying, some of our systems are down, we're sorry. And so as an intellectual property attorney, that just makes me cry. So we're a little bit stuck on their websites right now.
So I can just search for that specific word.
Yes,
Okay.
it does get a little bit more complicated than that though, because the standard in trademark law is confusingly similar. So if you've got a specific name, and there are different ways to spell it, for example,
Yeah.
for example, authentic pause, if somebody used the word P-A-U-S-E, that would be
Right.
too close because it sounds identical even though the spelling's a little bit different. So that can be the tricky part. So it's something that's a little bit of a variation might end up being too close. If you stick around for a couple minutes afterwards, I can do a quick search on it and see what I find, or you can even look it up on your phone and show me
Okay.
what you find, just so that it's, not on camera and everything like that. So from there, let's assume that the mark is open and available. Do you know when you plan on using it?
I'm putting together the program now, but
Okay.
I kind of wanted to protect it before I started announcing anything about it.
Right, yeah, that's,
So-
as an example of when we started Pirate Fight Club, I put the website up one day and I filed a trademark application the next day.
Yeah,
So,
yeah.
that's how nervous we are about people, taking a name that you spend a lot of time thinking about. So from there you would file the trademark application. Is your program are you gonna list it on your website? Okay, so then once you got it on your website or even a Facebook page, like I said, we could file the application pretty much the next day and kind of go from there, and then it takes about 6 to 9 months, assuming we don't run into any problems, then it would just register and we would send it to you and then you could use it for a very long time. The U.S. Patent and Trademark Office does require you to come back at the 5-year mark and say, hey guys, I'm still using this. And they'll say, okay, that's great, pay us our fee, of course. And then at the 10-year mark, again, you still have to show that you're using it, and then from there, every 10 years. And trademark is a little bit of an exception to the rule for intellectual property. Patents and copyrights do eventually expire, but trademarks, you can continue using them. So Coca-Cola, as long as they're using it, they can keep on using it.
And you just have to renew every 5 years with that.
Well, the first time is 5 years, and then it's just, and then at the 10-year mark, and then 10, and then every 10 years.
Okay.
And I think the idea behind 5 years is, if you're starting out, you've got these big, bright plans, and then, for some people, they don't end up working out, and what the trademark office wants to do is get that name back into
Right, for somebody else to use.
for somebody else to use. So that's why they do that.
So if I started using this specific word, and listing it like as the program and, using the name as a specific term and with everything that I do, listed it on my website, my Facebook, all these different places, would that give me any ownership of it at all without that trademark?
It gives you ownership rights in your geographic location.
Okay.
So,
The trademark is more nationally then.
Right. So it's interesting if anybody has, I didn't think this was going to come up. If anybody has followed the Redskins controversy on their trademark. Okay, so the idea is that the Redskins trademark is considered offensive, so what the trademark office did is that they canceled it. And very long story, but the Supreme Court ended up saying in a different but related case, no, free speech is gonna take over here and it's okay if it's offensive. But what I thought was gonna happen is even if the Redskins lost their trademark rights, they had geographic rights everywhere because the NFL is broadcast everywhere. So they'd still be able to enforce their trademark without the actual registration because they had that geographic footprint. For a company that's just starting up a program, it's going to be a lot harder to show that your program has a geographic footprint outside of Western New York. So that's where that trademark really comes into effect, and it's really, really powerful. We have seen local businesses start out, not get their trademark, try to get a trademark, somebody else already has that term. Well, they are still protected in the geographic footprint, but they wanted to expand and they weren't able to. So it can be, you know, a little bit of a difficulty for a business trying to expand after, you know, because they've got this 5, 7, 10 years of local branding and they don't want to change it just to be able to go national or even more regional. So it can be a hardship. So the trademarks they're very powerful and in my opinion, they're very important.
Is that costly?
To get everything on file for the first step is probably right around $1,000. So, so it's a sort of a significant fee, but it's not something that you really keep on having to pay for. So again, you come back at the 5-year mark, it's a couple $100, 10-year mark, a couple $100. And when a business is first starting, $1,000 is a ton of money because you start out, and I can't speak for everybody, but most businesses start out and you hang up your sign and you have no clients and you've got insurance expenses, rent expenses, equipment expenses, all of that. And then on top of that, somebody's telling you, oh, by the way, you need a trademark too. And you're, oh, good. So I'm not sure if you're familiar with the rule of threes, Jack, but I always forget the third one. The rule of threes, everything takes 3 times longer, it's 3 times more expensive, and 3 times as difficult as you expect it to be. And that's really true. That was very true for our business. We got an insurance quote for our business, and then we're like, oh, okay, that's reasonable, so we add it in, and then we get the actual number. Oh, you do intellectual property. Oh, no, that's a lot more money. And that was even, I think that ended up being closer to 5 times what we expected. And so I'm on the phone with the guy crying. But at any rate, we did get it to work out. Yeah, maybe that's another rule of 3, where you cry 3 times more often than you think you're going to.
Well, I started out as a DBA, and then Diana, I worked with her to change it to
do
an
the LLC.
So I feel like I'm doing things all over again that I did 3 years ago.
Yeah, that's exactly right, because the DBA is very straightforward. It's probably even with a certified copy, $75, and you're like, look at me, and you get your bank account and your employment identification number, and then you want to do the LLC, which I'm sure she gave you all the reasons why the LLC is hugely, and with the more recent tax cut that was put through earlier this year, the LLC is going to help you from a tax standpoint as well.
Protect your assets, pretty much.
And you protect your assets.
My personal ones, that's what I was concerned with.
Yeah, one thing I will caution about LLCs is, you know, we've been asked this question, if you form an LLC, you know, everything's protected, right? Well, actually, if you infringe somebody else's intellectual property as a single member or a small number of members in an LLC, your personal assets are not protected from actions of the LLC. So the bottom line is don't infringe somebody else's intellectual property, but that's why you're here. So if you ever see anything and you're not sure, always feel free to come back to Pirate Fight Club. If you're, writing a blog and you think, oh, I saw this nice photograph, can I use this on my blog? come back to our event and we can, answer that.
Can you actually answer like what kind of photographs are allowed to be used? Like you can find anything online,
Right.
just if you Google images.
Probably anything that's listed as a, Trixie, what are they called? Getting free images or something?
Yes, but not royalty free.
Royalty
I forgot what they're
free?
called.
I think there are certain websites.
It's in the public domain,
Right, something that's
essentially.
in the public
And
domain.
it's in the
So
public
almost
domain.
any photograph probably is very likely to be off limits. It's not particularly likely that you'd be caught, but the best course of action would be to contact the copyright holder and ask for rights to use it on your blog. I would think most copyright owners would not deny you, and they would not ask for a royalty because you're not really making any money off of your blog. But in terms of, I'm sort of picturing a blog for dogs or cats or something, try to take the photos yourself if you can get a photo.
Well, sometimes I'll create an event, like, a free socialization hour or something
Mhm.
like that. And I'll just take an image from Google just as the event picture.
Right, that's probably not something
Okay.
I'm going to recommend.
Okay.
If you find an image on Facebook, then you're probably okay because Facebook actually has a transferable, royalty-free
Okay.
license to that, and then you're indirectly getting the license from Facebook.
So if we take the picture
If you take the picture, you're
Yeah.
fine, you're the copyright holder.
without permission of whoever we're taking the picture of, or do we need permission?
I usually do ask the
Written-
clients. if
Yeah,
they're
I would
okay with-
ask them.
Yeah, because I usually take pictures during class too, and I'll say, does anybody have a problem with being on Facebook?
Right,
in
I would,
pictures?
yeah, they should be totally fine with that, because I take my dog.
So, I wanted to, I know I'm not supposed to tell you specifically.
Right.
So, I wanted to come up with, it's very broad, a medical device.
Okay.
And I talked to someone who actually created a patent in the medical field, but her patent is through the company she works in. So she's the inventor, but she didn't really, she's not making the profit. And not that I want the profits, I actually just want to help people, but
Okay.
so there's provisional patents.
Yep.
And then, so I have a year
Yeah, correct.
to get it all together. So, I don't know, I just was kind of coming in to see what kind of input I could get, information I could get from other, what was discussed at this.
Okay.
But I guess the steps to take, because obviously I'm going hopefully to be working with people to develop this medical device.
Right.
And, privacy and I know there's forms you can sign.
Yeah, non-disclosure agreements.
Non-disclosure, yeah. So, and obviously I don't want to get anything started with the provisional until I'm pretty much
Right,
ready to
right.
go.
Yeah. So the one thing that you won't find on the internet anywhere is that 1 year from the date of filing of the provisional to when the non-provisional is due, it goes by like that.
Right.
So they don't mention that. And
Yeah.
the other issue, of course, is, so assuming we did the work for you, if we filed a provisional, we need a couple months to get the non-provisional ready. So you don't actually even have a full year.
Okay.
So you've got maybe, 8 or 9, 10 months to kind of get everything ready. Have you invented the thing, or you've just got sort of an idea?
I have like drawings and ideas, but I haven't worked
And you
with
haven't
it.
disclosed it to anybody?
No.
Okay.
Well, like people that I can trust, but nobody,
But not the whole thing?
not the whole thing and not,
Right.
not
Okay.
into major details.
So keep it to yourself as much as possible. You can have, if you want to work on a prototype before you file a provisional, you can have the prototype developer sign a non-disclosure agreement. And then that protects you. If they tell anybody about it, then you can sue them on breach of contract. Once you've, there are some arguments about whether or not it makes sense to prototype before or after filing the provisional. We're patent attorneys, we're gonna tell you to file a provisional first
Okay.
and then do the prototype.
Why do you
Because dates are very important in the patent world, so the sooner you can get a filing date, the less likely someone else is to get into the patent office before you.
Okay.
So, but having said that, if you need a long time to do the prototype, then, and if you don't have the invention completely crystallized, then maybe it makes sense to wait on the provisional application.
Okay.
So, there are some different ways of doing it. Once you file the provisional patent application, to the extent possible, we still do encourage filing having somebody sign a non-disclosure agreement if possible. Some companies won't sign them.
Okay.
So, but and that's the other reason, because some companies won't sign them. If you've at least got potential patent pending rights in the provisional, then we're a little bit more comfortable with you disclosing it.
Okay.
And then from there, you've got, I don't know if anybody watches Shark Tank, but I'm not sure if you noticed this. The inventing and filing the patent application, that's the easy part. The hard part starts after that. You've got to get the prototype, you've got to get the manufacturer, you've got to get the marketing people, you've got to get distribution, you've got to get people to buy it.
Right.
So, so there's a lot of hard work that goes on behind the scenes, and I sometimes think for small businesses, you enter it and you don't know what you don't know. But if you knew that, I don't think anybody would start a business.
Right, I know.
Because there's so much hard work, and you're, wait, what? I have to file what form? Wait, I can't read that. Sign it anyway. All right. So there's just a lot of stuff that you don't even think about until, and it doesn't matter how much planning you do.
Right.
You just don't realize everything. So,
So you're saying I shouldn't do this?
no, that's not what I'm saying. I'm just saying if you knew everything that you were going to have to jump through, you probably
I know, I'm looking
wouldn't do
into it. I'm like, I know it'll help people, but it's going to be really difficult.
Yeah.
Yeah.
Yeah, everything in life is difficult.
I
The
work
parade of
with
horribles.
dogs that are sometimes aggressive, and
Yeah.
that is so much easier than filing paperwork.
Yeah. Yeah, the unpredictable dog is so much easier than a 10-page form from New York State.
I know what not to do, and
Yeah.
that's enough, and
Yeah.
then can go from there.
Yeah,
It's the parade of horribles.
Yeah, it is. Yeah, that's a thing that attorneys do. It's the parade of horribles. We kind of look at a situation and picture every possible thing that could go wrong.
It's
and
good
then,
though. You
yeah, it's good. It helps our
prepared.
clients. I think it sounds like you understand the difference between the provisional and the non-provisional.
Yes.
The provisional gets you a filing date. It will never convert into a United States patent. It's not examined. It just sits as a placeholder until the non-provisional comes in at the 1-year mark, and then it'll be examined by a patent examiner. Typically, the first round, they do reject the patent application just as a matter of course. There are very few cases that just are allowed upon application. They do that to get something on file, to get their thoughts on the record, so that people understand that otherwise it sort of looks as though the patent examiner didn't do anything. So unfortunately, that's kind of the way it is. Most inventions sit at the patent office probably about a year to 2 years. The pendency has actually gone down. In some cases, it's 3 years. We've had a couple that have come back within just a couple months, which is amazing, and also it's a little bit upsetting for the inventor because they just spent all the money on the application and now they've got to do some next steps, and they didn't really have a time to catch their breath, but that's just how it goes.
So wait, they
sometimes.
deny, they, what do? They deny
They
it? and then-
typically will reject the patent
Reject.
application.
So then you have to reapply? Or?
No, you make arguments in response. So that's,
Okay.
the attorney typically does that, and we know
Okay.
how to make those arguments.
Okay.
And then from there, they usually do grant it. Sometimes, when you ask,
Health insurance, where they deny it and then you have to argue it
Oh,
and then they
that's-
accept it.
yeah.
Yep.
And then in patent applications, there's something called claims, and that's where you claim your property. So in real property, you might try to claim this whole room, and the patent office will say no, and then you come back and just claim the area around the table. So so the patent attorneys will always start out a little bit broader and then narrow in, because you can start broad and go narrow, but you can't go narrow and then go broad. So that.
Easier to work with or a medical device company and just give them, or I don't know how I would put it. Like if it's gonna be so much work, would it
If
be-
you've got an idea and then
Yeah.
you file a provisional patent application, you may be able to assign your rights to the provisional patent application to a medical device company, or sell it outright,
Okay,
or license it to them.
okay.
That might work depending on what it is and if you can find the right target. Jack, do you have any
Yeah, I
experience
mean,
with that?
one of the challenges there is that, I mean, oftentimes an inventor would like, I mean, that would be great.
Right.
And the challenge is that the product hasn't been developed and de-risked enough for it to be of interest, so if even though maybe you've got the original patent, but, this company or this large company, they're gonna say, well, geez, we gotta do all the work.
Yeah.
And, so why should we pay you anything of any true value at all? So that tends to be the challenge that I've seen people have when they try to follow that path.
Okay.
Yeah. So this is an interesting month. This is Jack McGowen from Western New York Venture Association. And so he works with angel investors and any type of venture capital outfit, because that's what everybody needs is, you've got the idea, you've got this, but everybody always needs money. So then every month over the winter, they hold a meeting and there are presentations and there are venture
It's
capitalists.
like Shark Tank.
Yeah, it's just like Shark Tank, yeah, on a local level. And so the companies present, and then if there's a venture capitalist that's interested, they might get funding. And so so it's kind of interesting to have you here with your perspective, because we don't always see, we help with the patent application, but we don't always see what happens after that.
How do we get your contact information for the Shark Tank thing coming up?
Because I'll give you my card.
Okay. And so do we tell you specific, do we have to have a non-provision already set in place to talk to you, or how does that work? Because we're discussing
Right.
what we want to do,
So you,
or
I don't require it. You and your counsel may say,
yeah, a non-disclosure
we need
agreement.
something. But the reality of companies that present before the group, because it's in a public setting,
Right.
I always say, because so everybody who walks in the room isn't going to sign a non-disclosure agreement.
Right.
So, and just like similarly, if you're looking to go to, say you were going to go to you became more advanced, you went to a venture capital firm or something, they generally won't sign one either. So, if it's in a public setting, then I always say, well, don't disclose your secret sauce. You can talk about the business and the opportunity, and that's what people really want to generally hear anyway. It's not so much the how it works. They're just kind of,
Right.
okay, we've got data that it works.
Right.
And that means that it's going to solve that problem out there that our customer, we've identified this is the customers, they have this problem, we developed a solution. We can be a financially sustainable business, we've got the team that can execute, we've started to do it. Those types of things are really what people are looking for, not the secret of the intellectual property.
Okay.
Jack, I've heard different things. Do your venture capital people typically want to see a patent application on file?
Oh, yeah. If there's protectable intellectual property,
Right.
we want to see that things are being done to protect that, because that's, good ideas, competitors will pop up and
Yeah.
try to copy them. So, that protecting intellectual property, if possible, is very important.
Yeah, that's what we think too.
And that's one of the challenges we have. So, because our group is it's individuals, so it's not like we've got we're a firm, we got a big budget for legal expenses and that kind of stuff. So, you know, they'll come in and they'll say, well, I've got a, you know, and they, you know, may have a patent that's been awarded. But, you know, it's a challenge, okay, that's good, but not all patents are equal in terms of
Right.
the breadth of protection and things. So that's, you know, often a challenge and kind of a, you know, a risk that we often take is, okay, well, it's good that they've done that, but we really don't have a detailed analysis. Well, assuming that they have, I mean, like, if they use you know, we'll look at, you know, did you use a good patent attorney? And then we'll assume that, you know, if you did, then, you know, you've got as good as coverage as you can get.
So you want them pretty far along in the process? You
Right,
prefer.
right, because you know, the higher, you know, there's early stage investors are, you know, they're all risky, and quite frankly, most of them will not work out
Yeah.
at that stage. But you still want to try to, you know, manage the risk as best that you can. So concepts and ideas, generally, when you're going to third party strangers like our group, you know, they're generally not going to fund ideas. You know, they're looking for things that, you know, the product, you know, the technical risk has been managed to show that it'll work, or you got a pretty, you know, the market risk that, you know, you've talked to potential customers and you've got good indications that, you know, somebody wants to buy it, you know, that does solve a problem that they're willing to pay for. And then, you know, kind of the execution risk is that, you know, you have the team that can make this, you know, run this business and make it happen. And then the financial risk is, can we make money at it, and, you know, can we get to the points we need to get to before we run out of cash.
Yeah.
Turn cash positive before we run out, and then, you know, we either have to, investors have to put in more money, or the company goes out of business. So it's all about risk return and you know, assessing that.